Hi, Carl. I do see that you're online. Would you like to do a quick test of your presentation?
going to be a short meeting. All right, this is a call to order for the January 29th, 2026 meeting of the Santa Clara County Planning Commission. Will the clerk please call the roll?
Commissioner Heatherly.
Here.
Commissioner Cohen.
Here.
Commissioner Belska.
Here.
Commissioner Levy.
Present.
Vice Chairperson O'Donohue.
Here.
And Chairperson Rouser.
Present.
You have a quorum?
Item 2, Pledge of Allegiance. Please stand if you're able to join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good evening. My name is Mark Rouser, and I'm the chair of the Planning Commission. On behalf of the Commission, welcome to today's meeting. At this time, please turn off or mute all electronic devices, including cell phones, that may interrupt the meeting. The first item on the agenda is public comment. This item is reserved for persons who wish to address the Commission on any matter within the subject matter jurisdiction of the Commission that is not on the agenda. The law does not permit Commission action or extended discussion of any item not on the agenda except under special circumstances. Members of the public who wish to address the Commission on a non-agendized item should request to speak at this time by giving a request to speak form to the Deputy Clerk if you're in the chambers, or by using the raised hand icon if attending virtually.
We currently have no requests to speak.
Item 4, consent calendar. We are skipping because there is nothing on the consent calendar. Item 5, under land use, and we will turn it over to the staff for a presentation.
Thank you. Good evening, Planning Commissioners. My name is Laura Tran, Senior Planner, presenting on item number 5, which is a public hearing to consider an appeal of the November 21st, 2025 decision by the Department of Planning and Development to deem incomplete a concurrent land use application for the Silver Estates Housing Development Project, consisting of a major subdivision and grading approval for 44 units of housing, 38 single-family residences, and 6 below market rate single-family residences on approximately 16.8 acre parcel. Appellant Carl Gundquist, applicant Jim Campbell of Rome Development, property owner Robert Amami, property address location 19960 Almaden Road, San Jose, assessor parcel number 742-06-031, zoning A-20AC-D1-SR, supervisorial district 5, file number PLN 25128, SB 330, APL 1. So the project before you, highlighted, is located in unincorporated Santa Clara County, adjacent to the city of San Jose, city limit and urban service area. The subject parcel is zoned A-A20-AC-D1, which stands for exclusive agriculture, with a 20-acre lot size and setbacks combining district, and a design review combining district, and a general plan designation of open space reserve. The property currently has an existing single-family residence with a few accessory structures, and surrounding uses consists of a plant nursery that is adjacent, a goat farm to the south, the Almaden Quicksilver Park to the west, and the single-family residences to north and east. The subject parcel is approximately 16.8 acres in size. The proposed development is for 44 housing units, and related amenities include a U-shaped street loop, a wastewater treatment system, and a bioretention basin. Before staff presents the analysis of the appeal, it is important to understand the key milestone dates associated to this application. On January 27, 2025, the applicant submitted a preliminary application for the Quicksilver estate housing development project pursuant to the Housing Crisis Act, also known as SB 330. Under the Housing Crisis Act, submitting a complete preliminary application vests the applicant's ability to submit a formal application within 180 days. On July 22nd, 2025, the applicant submitted a formal application for the Silver Creek Estates housing development. The county determined the project application was incomplete and issued the first incomplete letter on August 22nd, 2025. On October 2025, the applicants resubmitted the formal application, and then on November 21st, 2025, the county issued the second incomplete letter. The county determined that the application was incomplete because there were still 2 items missing related to the land development engineering. Thereafter, on December 4th, 2025, the applicant appealed the incomplete determination. And on December 8th, 2025, the applicant resubmitted the formal application. And I also want to note here that the December 8th resubmittal addressed one of the incomplete comments, which is item 1A, but not item 1B. The first incomplete letter, dated August 22nd, 2025, identified 23 incomplete items, including 6 items from the Planning Division, 10 items from Land Development Engineering, 3 items from the Department of Environmental Health, and 4 items from the Fire Marshal's Office. After the applicant resubmitted on October 24th, 2025, the second incomplete letter dated November 21st, 2025 identified 2 incomplete items that are summarized and include showing the approximate width and direction of flow for all watercourses and show the state seismic hazard area on the tentative map. Moving to the grounds of the appeal, the appellant identified 2 reasons for the appeal. As for the first, the applicant states that per previous submission, contours were added plan-wide to denote direction of flow for all watercourses, and that the information is not required in the county's SB 330 submittal checklist. Staff's response is that the updated plan set, sheet C3.1, did not identify the directional flow of the tributary along the south property line, and therefore the application was incomplete at the time the incomplete letter was issued on November 21st, 2025. Additionally, the sample site plan from the submittal checklist requires identification of the existing drainage flow. One note that I want to add that the applicant did resubmit on December 8, 2025, and this item has been resolved as of today. So I just wanted to mention that for the Commission's awareness. The second ground of the appeal is that the applicant states the liquefaction limits were shown on the plan set, and the incomplete comment does not seek information listed on the county's SB 330 submittal checklist. The response from staff is that the applicant did not identify or label the area of the state seismic hazard zone, but instead only showed the liquefaction zone per California Geological Survey. Additionally, the county's SB 330 checklist requires the submittal of a tentative map, which needs to include the geological hazard areas per County Ordinance C12-20. Before moving to staff's recommendation, I would like to note that the total number of comments received for this item as of this evening are 93 comments, which have been included as part of the record. To conclude, staff recommends that the Planning Commission deny the appeal and uphold the Department of Planning and Development's determination that the land use application for the Quicksilver Estates Housing Development Project is incomplete as of November 21st, 2025. This concludes staff's presentation. We have representative from Planning and Land Development Engineering and County Council to answer any questions the Commission may have. Thank you.
Okay, can you just explain, you made a comment, this item has been resolved and is no longer an issue. How do you square that with the dates that we are looking at? December 8th versus was it November 20? So you mean you have the information, but that's not what we're looking at?
Correct.
Help me understand what that comment means.
Correct. So the applicant appealed on December 4th related to the November 21st, 2025 incomplete letter. However, they did resubmit on December 8th, 2025, and in that they did address one of the item comment from Land Development Engineering, which is the water flow.
Okay, okay. Got it. So you have that information, but at the date in question, you didn't have that information is what you
Correct.
were
For the November 21st, 2025 incomplete letter, those two items were still incomplete.
Okay. I'll open it up to the commissioners, and if you had any ex parte communication, if you can identify that. Commissioner Levy.
Yes, Mr. Chair, thank you. I had a conversation with staff yesterday to get a clarification on the issue associated with the seismic hazards. I will save my questions for after I hear from the applicant.
Okay. Any other commissioners have questions of staff at this point? Commissioner Hederly?
Yes, thank you. I'm wondering if you can tell us, did the applicant contact you following the August 22nd incomplete letter seeking any clarity about what was being requested?
No, it wasn't in regards to the discussion of the comments or anything like that.
Which comments?
So the applicant did not contact staff directly in regards to discussion of the incomplete items from the August 2025 letter.
Did they do so following the November 21st incomplete letter?
No, they did not.
Thank you.
If I could just ask a quick question, the second item, can you just explain a little bit more what you're asking for on that? That's the seismic. What are we asking? What are we looking for there to see if that was satisfied?
Sure. I can provide a brief illustration here. So this is to the right, there's a screenshot of, so this is the layer of the state seismic hazard zone, and it is required to be shown on the tentative map per county code. And this information can be found through our GIS system. It's also available on our public interfacing GIS system on our website as well. And this is just a showing of the state geological hazard area overlaid on the property.
Okay. All right, with that, we'll open the public comment portion, and the appellant, we can give, I assume they want to talk 10 minutes.
We currently have speaker cards for Travis Brooks, and joining online will be Carl Gutenkirst.
While he's coming up, can I just ask about how many speaker cards we have beyond them?
Certainly. Well, we currently have 4 speaker cards for general public comment, and on Zoom, it looks to be currently at 5.
Okay. All right, welcome.
I'm not sure if my mic is, okay, my mic is.
Just stand there and talk, and it should pick it up right there.
Beautiful technology. Hi, Travis Brooks, Land Use Counsel for the applicant. I have Jim Campbell and multiple representatives of Rhone, the applicant here. We also have Carl Gutekunst, I think I said that right, Carl, from Kieran Wright, who will speak after me and who's available on Zoom. We'll all be available for your questions tonight as the hearing proceeds. At the outset, I want to remind the commission that in addition to the incompleteness notice that is the subject of this appeal, the applicant received a separate letter on November 21st indicating its position that it believed Rome lost its vesting under SB 330 because staff didn't think the project application was complete after its first resubmittal. Typically, these sort of minor disagreements where there are reasonable differences of opinion as to whether an application is complete are resolved without having to go through all the cost and delay of these appeals. So anyway, the only reason why we had to appeal this was because staff issued that separate letter. And I just need to point out that that position that staff took in that separate letter is contrary to the positions that have been repeatedly taken and issued in assistance letters from HCD. The State Attorney General's office recently issued a technical letter. And then I can now say 3 courts, trial courts, have also agreed with our position on this matter. And I can say 3 trial courts have now taken our position because today the Santa Clara County Superior Court just decided this issue for a different project. Judge Williams of that court, who would likely hear a lawsuit, certainly the Santa Clara County Superior Court would hear any litigation here, and Judge Williams would as well. But in Judge Williams' words in the order issued today, the court is convinced that SB 330 allows for multiple 90-day resubmission periods for a project proponent to respond to successive incompleteness determinations without losing the project vesting conferred by a preliminary application. So at the outset, I'd just like to say, regardless of the outcome tonight, I would respectfully ask the commission to direct staff to comply with the HAA and all this overwhelming guidance from every outside source that has authority, and honor this project and other projects' vested rights under SB 330, even if they are not deemed complete after a single resubmittal. The HAA requires the county to process this application in the manner that affords the fullest possible weight to the interest of and approval and provision of housing. This pro-housing interpretive mandate applies during the application completeness process. Therefore, the county must comply with the Permit Streamlining Act's pro-applicant rules. For example, for completeness purposes, the county can't request the applicant to provide any item not listed as specifically required on the application checklist that applied at the time the applicant submitted their application. They can't add anything new to a subsequent letter. In 2025, the legislature added some additional rules to protect applicants during the completeness process, and these are relevant here. For example, a local agency can now violate the HAA and therefore be subject to a lawsuit if it finds an application incomplete, but a reasonable person would conclude that the applicant submitted all the items listed as required on the local agency's submittal checklist. And now I'm going to turn it over to Carl, who's hopefully able to break through on Zoom, who will explain why the submittal that the applicant provided in October of 2025, reasonable person would find that that submittal included all the materials required to deem the application complete.
Good evening, everyone, and thanks for taking the time. Can you guys hear me okay there?
Yes, we can. Thank you.
I sent a quick slide deck prior to this meeting. Was that able to get through, or can I just share screen on Zoom?
You are able to just share the screen right now if you'd like.
Perfect, thank you.
And can you pronounce your last name?
You know what, you guys all had it close enough. It's Kudukost.
Thank you.
Of course. So Laura kind of went through a lot of the items that we wanted to talk about. So I'm going to skip forward here, and I'd like to focus on how these specific comments were phrased on the checklist and how our team felt about responding toward them. So the 2 items in question here are highlighted: the existing drainage patterns and drainage patterns as a result of the proposed improvements show areas of flooding for the 100-year flood, and any known soil or geologic hazards here as well. The October 2022 submission, we all felt like that it addressed these items. You can kind of see here that the liquefaction limits are shown highlighted in yellow as we're going page north to south. Now, Laura brought up some great points about showing these limits, and on the first application, we had not shown these, so it was responded to in October of 2022 with the state liquefaction limits alongside our work with the geotechnical engineer. And apologies as I pan around here. with work with the geotechnical engineer to as well confirm that there were no susceptible hazards to the site in regards to geologic concerns. This item was one that as well came back to us as part of the second response letter that Laura mentioned, with an added component that they said a simple statement will not suffice, as the actual approximate locations and the type of hazard area must be shown on the map. The hazard area has distinct approximate boundaries which must be shown. And note that she called it the state seismic hazard zone. We felt, again, like this response that we gave on the resubmission was adequate in the way that she was looking at this and the way that Daryl were looking at this. And the liquefaction limits were continued to be discussed offline with their team. And it wasn't until a later discussion where we realized that they had been asking not just for the state liquefaction limits, but also the county liquefaction limits, which was not an item that was discussed in the first or the second letters. Item number 2, regarding the existing drainage patterns and drainage patterns as a result of the proposed improvements. Our team did work to show these areas, and we did that via contours. You could see this on the map here, and this is something that we felt any person who'd seen a map before or layman would be able to understand, that the contours down the page, I'm going to zoom in here a little bit, depict how water would flow down a site. You can see a 370 here, a 365 here, a 360 here, that denote how water moves down an area. Now, we did this to show that the water was moving from page left to right, and then went around the whole site to make sure that we further identified areas of storm drains. You can see here that we had an area that's going page left to right, it's flowing down the hill. We had Alamitos Creek as well, which we gave a proposed storm drain easement to. And we gave one to this small tributary creek here on the bottom with the 5-foot proposed storm drain easement. This, in combination with the contours down the page, meant to imply that water flows down, and as well labeled the areas with which water was going to be found. For these reasons, we felt that the comments that were provided in both the October and November letters were not sufficient, and any reasonable person would be able to understand the concepts of what was going on. And at this point, I'm happy to answer any questions further.
Just keep going, and if there are questions at the end, we'll ask them.
Yeah, that's standard is if a reasonable person would conclude that our application was complete based on what Carl just explained. It doesn't mean all reasonable people have to agree on the same conclusion, but if a reasonable person would conclude that we submitted that information, you shall deem our application complete. And that language was added as part of the HAA because the legislature, it sort of filtered through that as the substantive reasons to deny these projects have gotten harder, it's really the completeness process and other procedures where local agencies are frustrating state housing rules. So that's all I have for now. We're happy to take your questions.
Okay, on the last item, the state, what was that called? The state hazard?
Liquefaction, state hazard zones.
State hazard zone. Do you feel that that's properly being displayed on here, or what is your position on whether or not the initial checklist called for that?
There's 2 big parts here. The first one was from the engineering side. We wanted to make sure that there were no geologic concerns on site. And here I'm moving to the geologic letter here. We did work with the geotechnical engineer who's licensed in the state of California to confirm that there were no hazards on the site. That's kind of our first check that says, hey, there's nothing here that from an engineering perspective, anybody who would live here would need to be concerned with. And as you can see here, all of these items were confirmed that there were no hazards on the site. And this document was submitted with our first package, so the team definitely should have had it. Alongside that, we did confirm that there are zones in this area. You can read here that Alamitos Creek has a seismic hazard zone for liquefaction, as well as Santa Clara County designated by liquefaction hazard zone. I think the issue here is that county letter, and I'm going back to it now. The county letter listed the state seismic hazard and liquefaction hazard zones, and as well, when Laura was sharing her screen, she was showing us the same document, which I can actually show here as well. The way that the comment was phrased, as well as the lack of any geotechnical hazards on the site, made us believe that the state zone was the one being requested. as I mentioned earlier, it wasn't until later that the county further clarified that they were looking for the county hazard zones alongside the state ones, which again was not listed in there first. So it's kind of two factors here. One is that there were no hazards on the site other than being in the zones. And number two, that the full county and state requirement was not listed until a much later letter.
Okay, so it's your position that the report from your geologist was enough to state what the hazards were on that property?
Alongside us listing what the action limits here, I tried to highlight it on the this is our resubmission document that you see.
Right.
I'm not sure how well it comes across on your guys' screens, but it's highlighted down here throughout the page.
Got it.
But yes, to answer your question, we did feel like this was an adequate response.
Okay, Commissioner Belska.
Yeah, thank you. So there's a state hazard zone and a county hazard zone, and what was the third one?
I'm sorry, there is a state zone. Can you see this okay?
Yep.
Apologies, I'm jumping around from item to item here. The state zone is being shown currently.
Okay.
If you turn that off, you can turn on the county zones, which is here and here. This is the orange to the right is a landslide zone, and the one to the left is a liquefaction hazard zone. Now, again, both of these are the county ones, and our geotechnical engineer did confirm that neither of them are a concern to anybody living on the site. And as well, the state hazard zone was the one that we had shown and the one that Laura had been showing on her screen.
And okay, so the one you showed was the state one. This is what you're showing right now is the state one.
Correct.
The slide from planning was showing the state one. So then I'm confused. Who is asking for the county one, and where was it? What's missing?
I believe the letter that the county was saying is that they wanted to see state and county lines.
Through the chair, if I may.
Sure.
Can I request land development engineering to specify in terms of the two zones that you're referring to?
That would be very helpful.
And if I may, just one point of clarification, and Carl, you can confirm this. The application checklist itself does not list the county liquefaction zone. It only lists the state. Is that right?
It sounded even more generic than that.
It says any known soil or geologic hazard areas.
Good evening, Darryl Wong with Land Development Engineering. So in my comments, we were just asking for the geologic hazard zones. And so the geologic hazard zones are used in general to describe whether it be county hazard zones or state hazard zones. And so I think Carl has nicely provided those on the screen. The differences between the county landslide hazard zone, the state seismic hazard zone, as well as the county liquefaction zone. There are 3 zones. Through their submittals, they showed one of those 3 zones.
That's the liquefaction hazard zone.
It was the state seismic hazard zone.
Which is the one seismic hazard zone listed on P.
But
And see, liquefaction hazard zone could be county or state. It's not specific.
Yeah, and this is where this whole process, because.
well, yeah, one at a time. So
Because you could read that as just requiring state.
The liquefaction on the plans now, I'm asking staff, what do you think that represents? Which of those three does that satisfy or none of them? So on the plans, they showed liquefaction, right? Lines highlighted in yellow?
The highlighted yellow would
Yeah.
be one of the three zones, and that would be the state seismic hazard zone.
Got it.
And sorry if I may.
Go
jump
ahead.
in here. There are multiple online offerings for geotechnical hazard zones. There's not only the county one that I believe Laura and her team are referencing, but there's also the state of California one, which is shown here. Very similar in concept, you'll see a lot of the same data. If I kind of pan between these two, you can see that this green zone is meant to be the the state zone that we're discussing at this moment. Here's our parcel 742060331, and here's the same. The difference here is that on the California state website, they do call it a seismic zone, but it's further specified as a liquefaction zone, so a state liquefaction. It's kind of one of those a rectangle square kind of issues where one can be both, not just one being over encompassing. So when we were looking, again, using the county provided letter, which required us to look at the state zones, we of course went to the state website first to look at that, and that's where we had the liquefaction limits. So yes, Daryl is correct in calling this the, how is it worded? The state seismic hazard zones, but it is further defined if you go to the California page as being a liquefaction zone. So that's why we're showing it as such, and why we thought it satisfied the original comment provided by Daryl.
Okay, and to staff then, they showed one of those and the other two would have shown something slightly different, more or less?
That's correct. I think Carl actually has our GIS up on the screen. So if he were to click on, for instance, the county landslide hazard zone and highlight that, that's a completely different area. And that's one of the three that would have need to be shown.
Is that the light green or the tan-ish? That, okay.
Yeah, it's that one.
Okay,
Yeah.
got it. Any, okay, I don't know who had it first. We'll go with Commissioner Belska.
I just wanted to clarify because, so the state liquefaction seismic hazard zone, the state liquefaction hazard zone and the state seismic hazard zone appear to be identical. Am I
Right, the state
correct?
defines it as yes, so the state defines it as a hazard zone, just any seismic hazard zone. And then it's further clarified as specifically a liquefaction zone if you go to the state website, which is here. I don't know, again, I'm not
Okay.
sure what you guys can see.
Okay, so they are one and the same. So that request in the comments that said show the state seismic hazard zone and, there we
Yes.
go, thank you. The state seismic hazard zone and liquefaction hazard zones, those are the same, one on
That is
top of the
exactly-
other, exactly same boundaries.
And the way it's capitalized, I mean, it looks like it's one, I mean, it looks like it's on the same map.
But I mean, even if they were two separate things, in this particular case, if you look, it seems like the maps are showing it in exactly the same location. One is the other, right? They're equivalent.
That is correct.
Okay,
And that's why we felt that the way we depicted our drawing, and I'm sorry, I'm panning again, depicted our drawing satisfied that comment.
okay, and so it sounds like the point of contention then was that the county landslide zone was not shown. Is
The
that?
county landslide zone and the county liquefaction zone, that is correct.
Is the county liquefaction zone any different?
Yes, give me 1 second.
Okay.
The county liquefaction zone is slightly larger.
Got it. Okay. But those were not, all of the comments refer to the state zones, and the county zones were never specifically asked for.
Correct.
Okay, all right, thank you.
Commissioner Hederly.
Yeah, I'm going to complicate it a little bit further. So I'm looking at the letter. I think this is the letter. Yeah, the August 22nd letter, which is what we have on the screen now. But on the checklist, it seems to say that all known soil and geological hazard areas must be identified on the tentative map. Now, I wouldn't claim to necessarily be a reasonable person, but personally, I would assume that meant all known soil and
Yeah, no, that's a good,
geological hazards. And your geological study does identify fault lines, it identifies landslide areas, and it identifies liquefaction zones. Those all three seem to me to fit in that category, but the only one you chose to show on your map was the liquefaction. Now, I'm hearing that that was because that was the only one that you believed was an issue of concern. But this doesn't, the checklist doesn't ask you to make that judgment. It asks you to show all of the areas. And I have a follow-up question also about the image you showed us of the map with the highlighted yellow line showing the liquefaction zone. That, to me, in my perception, is very different to see a single line than to see an entire area. It feels to me like what has been requested was the area, not a line within the area. So I'd love to hear your response to that.
yeah, and I can answer the first question, and I'll refer to Carl for the second question. On the first question, the way the Permit Streamlining Act works is it's a narrowing funnel, basically. So, the applicant, when they first put their application together, they're looking at a very detailed application checklist that, requires hundreds and possibly thousands of items. They submit that application, obviously, and then once the first incompleteness notice is issued, the county is required to identify anything that it wants to say is incomplete in that first letter. So for the purposes of determining whether or not an application is complete after that first completeness notice is issued, the only thing that the county can point to, and this is spelled out very clearly in the Permit Streamlining Act, are the items that were identified on that first incompleteness notice. And it's really designed, so you don't really go back to the first step. Each step you're narrowing down.
But that does include, the language just went away, but it includes all known, I don't remember the phrase now. Can you put
Sorry,
that?
I'm getting back to
it. Thank you. Approximate known soil or geological hazard areas, including but not limited to state seismic hazard and liquefaction hazard zones. That it's pretty clear to me that including but not limited to means exactly that those two specific called out areas are not necessarily the only ones. So that seems like something that should have triggered some clarification questions. Yeah. And again, the areas, you haven't had a chance to answer the areas versus line question.
Yes, I'll just briefly answer that question on the including but not limited to. So this is another point where I insert an annoying lawyer point. So under the HAA and under SB 330, the applicant's only required to comply with objective standards and requirements, and those are standards that are not subject to any interpretation by staff, and they're uniformly verifiable by the applicant and the county. So when I read this, including but not limited to, that is an entirely subjective requirement. The objective requirement here is the state seismic hazard and liquefaction hazard zones. And under state law, that's really the objective requirement of this list. That would be our position on that. And I'll, unless you have any other questions on that, I'll refer to Carl for the second part. Carl, are you there?
Are we good to move on?
Oh, sorry.
Yeah, sorry. Are we good to move on to point number 2?
Yeah.
Okay. And apologies as well, I did not intend to show the full submission here. The full submission comments, would take hours to go through. So what I have presented here and what I believe the board has is just a quick snippet of our full set. I just included another page from our set, and I'm happy to send that along as needed. But I've included now page 3.2. The way that civil plans kind of work together is that they have numbers down here, which kind of implies to the reader that plans are kind of meant to ride together. In this case here, and you can see it on the screen, if I zoom in here, there's a match line on this sheet which says go to sheet 3.2, which I'm panning to here. I quickly did highlight that the other end of the liquefaction limits are shown, and on that C3.2 sheet, you see both sides of the liquefaction limits on the left and the right. And sorry, I didn't highlight this one in time. Just gonna cloud it. But this was obviously meant to imply the area within is that bound by those liquefaction limits. And again, these were the state seismic and liquefaction limits, which were the comments that we were just looking on the screen.
Did staff recognize that there was two limits and it was within those two lines, the liquefaction zone for that particular one?
Yes.
Yeah, okay. Any other questions from the commissioners? All right. You have a minute and a half left, but we will give you 5 minutes of rebuttal at the end of comments, so.
Yeah, I think that's, unless Carl, you have anything else, I think we're good.
Okay.
Yes, that's good. Am I okay to stop sharing?
Well, you were actually very handy, but I think we'll take it from here. Thank you.
Thanks so much.
Would you like to go ahead and call the other speakers?
Sure. We currently have 4 requests to speak in chambers, and looks like we're holding at 6 speakers for a total of 10. So I will call our first speaker, and we'll give them 2 minutes.
2 minutes apiece.
2 minutes. Okay, our first few speakers are Steve Wilkinson, Rich Griffiths, Keith Lubliner, and Xavier Campos. You can just go and line up. Any order.
So again, there's no actual microphone, but if you just speak forward, we should hear you fine.
Okay, thank you. My name is Steve Wilkinson, and I've lived in Almaden Valley for 45 years. I'm here tonight to ask you that you deny the appeal request. I frequently use Almaden Road to access Quicksilver Park and visit my friends who live directly across from the proposed development. The surrounding property is a high hazard area, a fire hazard area, and a fast-moving fire could result in loss of lives with limited exit routes. The developer is seeking this development, is pushing this to the Planning Commission. The proposed residential development is in a rural 2-lane road zoned for agricultural use. The site provides a wildlife corridor, including at Alameda's Creek, and it's not an ideal spot for dense housing. All these reasons, these are all reasons for not approving the development on this site. You have a difficult decision to make. I'm thankful for the opportunity to address the Planning Commission. I urge you to accept the staff's recommendation and reject the builder's application appeal. Thank you.
Hi, Rich Griffiths. Lived in Almaden for 30 plus years. Actually, I thought I was just going to be talking about some general concerns like the previous gentleman, but the discussion about the liquefaction zone piece actually drew some attention of mine. It does seem clear to me that the developer and engineers were aware of all of the different seismic zones, including the county zone as they pulled it up on the GIS, and that the county zone is significantly larger than the state zone and seems that it would cover a large part of where the development is planned to be placed. In addition to that, just coming back to my original general comments, is it does seem a little haphazard to drop this size or density into an area that does not have the infrastructure to support it. Especially concerning is the lack of sewer and putting in essentially a private sanitation district for these 44 houses. Also concerned about, given the wildfire urban interface, how these people will get homeowners insurance, as I know that I and many people of my neighbors have significant trouble getting coverage for our houses in this area. And then just generally concerned about how do the exceptions and the variances work to the general plan and zoning. This is a very significant outlier with respect to the open space aspect of the general plan and to the agricultural 20-acre zoning, as well as nobody brought up the scenic route aspect of Almaden Road, but the combining district of the scenic route, I think, is also a significant aspect to take into consideration with respect to putting this kind of density plopped out in the middle of the country. Thanks.
Thank you.
Hello, my name is Keith Lobleiner. Thank you, commissioners and neighbors. I'd like to ask that you deny the appeal, and I have a couple of points here. One is I don't believe that this, rural development was in the spirit of SB 330, and I think as such, since the window for SB 330 is closed, infinite extensions don't seem to make sense, and it leads to sort of chaos if the process and the rules are not followed. And I guess I'm a big believer in following rules to some extent. Yeah, and so, like I said, the window was missed. If we extend this, then that applies to, I think there was 40 other submittals, and I just think that causes too much chaos. Thank you for your time. I yield.
Thank you, Mr. Chair. Javier Campos with VER Engineers. We're not the civil engineer on this project. We were asked to review the two comments. One of them got resolved. So we have had several SB 330 projects that we've worked on that had been deemed complete. And I do believe just going to the SB 330 builder's remedy legislation and law, the intent of the checklist and the whole process is to vet out projects that don't even see the day of light of being able to be built. And the issue becomes completeness and consistency. And I think as you review this project, and staff has put a lot of work in reviewing this project, that the issue of the liquefaction zone and the hazard zone being shown or not being shown on the tentative map or on the civil plans, that all of those hoops are going to have to go through to prove that this is a viable project. Those are consistency items, and I think it was shared as this discussion started with the attorney, I'm forgetting his name, that a judge ruled that, okay, you get 90 days to get your comments back in. If there's additional questions or comments, then the judge ruled that the state's intent is, okay, you'll get another 90 days, because the whole goal is to build housing. And this project will have to also provide 6 affordable units. And I think that that's very valuable given that California is in a housing crisis. So thank you for your time, and I urge you to support the project.
Thank you.
Moving on to our Zoom speakers. Our first speaker is Alice Kaufman. Alice, you will have 2 minutes.
Thank you, Chair Rouser and Commissioners. My name is Alice Kaufman. I'm the Policy and Advocacy Director for Greenfoot Hills. And we urge you to deny this appeal. As was recognized by Commissioner Hederle, the incomplete letter asked for known soil or geologic hazard areas, including but not limited to state seismic hazard and liquefaction hazard zones. And the argument that that language in the letter should be read to ignore the first part of the sentence and only focus on the second part just does not make sense. The applicant clearly was aware of the county hazard zone information, could have easily included it. They also could have asked staff for clarification on what exactly was meant by that phrase in the incomplete letter. And again, staff has confirmed that the applicant did not contact them about those items after either incomplete letter. And I think it's worth mentioning that as of this date, at least 13 builders remedy projects have been deemed complete by planning staff. You may not be aware of this because when an application is deemed complete, that decision does not come in front of this commission. It just quietly moves into the environmental review process. But although you've considered several incompleteness determinations, it is worth noting that more than twice as many projects somehow managed to provide the required information within the deadline. And it's not because their sites were less challenging than the others. They're all located in rural areas where there's no existing infrastructure, just like the projects that have come in front of this planning commission. So the requirement to have a complete application by the deadline is entirely reasonable, and you should deny the appeal. Thank you very much.
Our next speaker is S. Remian. You will have 2 minutes. Your mic is open. S. Remian, your mic is open. You will have 2 minutes. It appears you muted your mic. Would you like to unmute? We can come back to you. Our next speaker is Kelly Lanspa. Kelly, you will have 2 minutes.
Hi, I am a resident of New Almaden, so I drive this stretch of road every day. And I urge the commissioners to reject the builder's appeal. This parcel functions as a wildlife corridor, and these animals are traveling. I see them every night and every morning. They're traveling from Quicksilver Park to the creek and then off into Santa Teresa parks. And that's a massive amount of area that these animals need to traverse, and this would put something right in the middle of that. This is also a national scenic drive, and altering the rural character and viewshed would really hurt that national status. Also, this site presents a significant safety and infrastructure concern since it lies within high and moderate wildfire hazard zones, and nearly all of the proposed development is in a liquefaction zone, which is raising serious earthquake-related stability issues. Also, the private sanitation and septic systems in a sensitive rural setting is very concerning and raises concerns about the long-term reliability and environmental protection in this sensitive area. And then placing 44 homes on this site represents residential sprawl. It's consuming open space, increasing vehicle miles traveled, and placing houses in hazardous areas, and increasing long-term public service costs to get out there and to service these people. So for these reasons, I urge the commissioners to deny this appeal. Thank you.
Our next speaker is Hugh Scullin. Hugh, you'll have 2 minutes. Hugh, your mic. I can, thank you.
I am a resident of New Almaden as well, and my house is on Los Alamitos Creek. I have visual and photo evidence for anyone's interested of mountain lions, coyotes, fox, deer, skunk, whatever other creatures you can imagine. And they live here too. I think any project that goes into this type of environment requires a wildlife corridor be instituted in the design. As far as the septic system, basically it's a septic system for 44 houses. I have my own, a 1,500 gallon tank. Of course, the science is a little different, but I think it's a major stretch to have 44 houses in a rural setting, basically leaching out to Los Alamitos Creek, which has recently been seen as a corridor for Chinook salmon. I just hope you consider this along with the liquefaction. It seems like a push, and you're less than maybe a couple of 1,000 feet from a city septic system or a city sewer system. Why would you, put in something like this that's going to put that kind of pressure on a natural resource, as well as the scenic highway? This is a beautiful area. We don't want it to change, as you can imagine. And I've seen it change. It's already shrunk quite a bit. And that's just what the city does. It just keeps moving out. Thank you.
Our next speaker is Junior. Junior, you will have 2 minutes. Junior, you're able to unmute your mic. Appears you may be having some technical difficulties. We'll move on to our next speaker, San R. You will have 2 minutes.
Good evening, Chair and Commissioner. Speaking on behalf of myself only as a county resident, I live in a similar area where my property is one home away from the county boundary on the hillside. So my entire street and the adjacent street that I live on are all properties that were built in the 80s and 70s, and behind us is county hillside. And what I can tell you is we cannot get insurance anymore. I've been struggling to work with Homesite, which is my insurance provider through Geico, and they're increasingly putting in conditions where it costs us a lot of money to get insurance on these kinds of locations. We can no longer get insurance from Farmers or State Farm or any of the other vendors. Homesite and its subsidiaries are the only ones that will insure in these areas. We also see quite a bit of concerns around continued wildfire risks in these areas, particularly as the county hillsides need fire management, which is an increasing risk. And so I urge you to deny this appeal and deny the project. We are in a situation where the county lands need to be preserved for maintaining the wildlife corridors, for managing the wildfire risk, and just being aware that insurance is increasingly impossible in these peripheries where the hillsides meet the existing subdivisions and tracts. And so I urge you to keep that in mind. We don't want to have these corridors being built and then nobody can get insurance, and then it turns into blight because people cannot actually maintain a mortgage if you don't have insurance. So urge you to reject this project and do the same with any other hillside projects that the county may be receiving. Thank you.
And we're going to, excuse me, try for S. Rimian again. S. Rimian. Your mic is unmuted. You'll have 2 minutes. It appears they're having technical difficulties. We'll move on to Junior again. Junior, you'll have 2 minutes. Your mic is unmuted. Yes, we can hear you now. Thank you.
So good evening, Commissioners. My name is Jyoti Reddy, and I live at 20010 Almaden Road, 2 homes from the proposed Quicksilver Estates project for more than 20 years. I am very familiar with the recent state housing laws and fully supportive of meeting California's housing needs in appropriate locations. I'm here to urge you to deny this appeal because the Quicksilver Estates project is not eligible for SB 330 or the Builder's Remedy. Both SB 330 and the Builder's Remedy apply only to projects that submit a complete and qualifying application within required statutory timeframes. The record shows that this application was incomplete and never vested. Because the application failed to vest, neither SB 330 nor the Builder's Remedy applies as a matter of law, and this commission retains full authority to enforce the county's A to 20-acre zoning and deny the project. Also, there is a clear and independent basis for denial under Government Code Section 65589.5 D4. The project site is zoned for agriculture and is surrounded on at least 2 sites by agriculture or resource preservation land, including APN 742062023, which is my immediate neighbor on 20000 Almaden Road, which is an active goat farm, and the other APN is a nursery. This is precisely the type of agriculture setting the statute was designed to protect. Section D4 further allows denial when a project lacks adequate wastewater facilities. Quicksilver Estates proposes 44 high-density septic leach fields adjacent to a creek. Even with 150-foot setback, the cumulative night road loading from this level of density poses serious threats to groundwater quality. For these reasons, I request for a CEQA environmental impact report, deny the appeal, and determine that.
And that concludes public comment.
We'll go ahead and allow the appellant 5 minutes to rebut any of the comments you heard or any other information pertinent to this.
Yeah, and I won't use 5 minutes unless, Carl, you have something to add. Just to the specific nature of this appeal and completeness issues, just to return it back to base. The base issue, I think, in the county's processing of this application, in making this completeness determination, it is directed by the HAA to afford the fullest and possible weight to the interests in the approval and provision of housing. I think it's clear that reasonable people could disagree, sort of based on the technicalities and minutia of the different maps involved, that, a reasonable person would conclude that, we're complete as of October 24th when we submitted that submittal. And, maybe another reasonable person could disagree. But with that pro-housing directive, I think that pro-housing directive is violated if you go with the position that's, opposed to that other reasonable person's position that would be more pro-housing. I'd also like to address, there was a comment that, somehow this project wasn't deemed complete after one resubmittal, whereas several others have been deemed complete after one resubmittal. I think that's by virtue of timing. My understanding is that the county wasn't taking this 90-day loss of vesting position until its housing element was deemed substantially compliant with state law. And my understanding is there are several SB 330 Builders Remedy projects that were just earlier in the process that had multiple resubmittals, didn't lose their vesting, and that were then deemed complete. So I just wanted to make clear, my client has been extremely diligent and isn't some outlier. They just diligently went through the process that all projects go through. Thanks, that's all I have.
Okay, with that, we'll close the public hearing and bring it back to the commission for discussion. Commissioner Belska.
I did actually want to get a little more clarification from staff. We talked at depth about the seismic hazard item, but I do want to understand what was missing for the other incomplete item and how, if you can share, how that was eventually satisfied.
Through the chair, if I may, the other item I believe Commissioner Belska is referring to is the water flow,
yes.
the flow of the water course for the tributary, and that was, and I can also defer to land development engineering to jump in for the technical details, but that was addressed in their resubmittal on December 8th. So land development engineering did deem that item complete. The applicant did address that.
I understand that. I'm trying to get a visual here of what was the scope of changes that we were asking for? I mean, was it literally they added one arrow to the map and you said, okay, now it's good? Or, was there, how was that comment satisfied? What is it that you were looking for that was missing from the previous maps?
Sure. Again, Darryl Wong, Land Development Engineering. So on the, I guess it would be sheet 3.1 that Carl had shown up earlier, the main creek, Alamitos Creek, there was flow arrows. So it actually shows the direction of the flow in that main creek. In the tributary Blue Line Creek that runs to the south, I guess on the southerly portion of that property line, there is no flow arrows at all. So those flow arrows, and you would say the flow line would be called as a flow line of the creek. And so that's typically what you'd look for.
If I may, I can show the difference. I missed who the original question originated from, but to answer your state, yes, it was as simple as showing a flow arrow. And I'm happy to I don't know if I can.
Okay, I'm sorry, we closed the public hearing.
Sorry.
Do you want was staff's answer adequate for you?
Yes.
Do you like to see that sheet?
I mean, it sounds like they're saying, yes, it was literally just add an arrow, was the entire.
Does water flow from high to low, typically? I mean, there are places where it could pool and you can kind of go back up, but for the most part.
It does, but on the plans, there's not even a call out that there's a creek there.
Okay, so you wanted to identify what the creek was?
The point of the requirement is to show where all the creeks and water courses are on the property. So anyone who evaluates the project, good or bad, right, can see where the creeks are. On sheet 3.1, as you see in front of you, as it says lands of Griffiths, along that property line, there's actually a Blue Line Creek.
Can you define what's a Blue Line Creek? Is that the name of it, or is a Blue Line something land engineering knows about?
It's considered that by the water district. So it's just a categorization.
Got it. Okay. All right.
So it's a tributary creek. But on the plans, it's not identified as anything. So while an engineer or a surveyor may be able to look at the topo and try and see if there is a flow of water there, I'm not sure that it's readily obvious.
Is that seasonal or is that year-round creek?
It's a tributary creek, so it flows when when there's precipitation.
Got it. Did that answer your question, Commissioner Belska?
Is it possible to see the resubmitted plans that you were satisfied with? Again, I'm trying to get a sense of what was the delta here, right? Like what was the scope of the changes that were specifically being asked for?
Sure, I can pull up the plans. Give me one moment.
Maybe we can move on to other questions.
Yeah, Commissioner Hederly, did you still have a question, or?
I had the same question
Okay.
and a tiny bit of follow-up. And I also wanted to just clarify that this informational is it's been taken care of now. Doesn't really tell the whole story because it wasn't taken care of, whatever, we're gonna see what that looks like until after that second notice of incompleteness. So I don't think that a December 4th submittal meets the deadline for completeness. So while it would be useful to understand whether we were just looking at an arrow as opposed to something else. Even the fact that staff is now satisfied with this current presentation is not sufficient to say that this item was completed prior to the deadline.
So through the chair, if I may, so this is the plan set. I'm going to zoom out a little bit, and you can see I'm going to zoom in. Pardon me for one moment. So here, as you can see, this is the tributary that Daryl is referring to. And there's arrows that's pointing to the flow. So this is the resubmittal that the applicant submitted on December 8th to address item, the first item.
And that was within 90 days of the incomplete letter, the December 8th?
This was after. So this plan that you're seeing was resubmitted on December 8th, which was after when the applicant filed the appeal. So it was after.
After the 90 days?
Correct.
Okay. I would like to get from the department, based on the legal ruling that came today, what has the county's position changed at all as far as the date goes?
So we're still evaluating the ruling that came out today, was issued, or we became aware of it in the late afternoon, to determine how it will apply to the county moving forward. I'll just note that the town of Los Gatos did have a slightly different process and argument from the counties, and so we just need to evaluate. We will be taking that into account. But again, the issue of the incompleteness determination, I think staff has rightly focused on the November 21st determination, which is what's before the commission today.
Understand, I think it would have been very transparent for county staff to let us know of that update, because we've all been very interested in that. So I'll just put that out there, that rather than coming from the appellant, that would have been nice to come from county staff. It doesn't change what we're looking at, but it's still very, very, very relevant to these cases.
Just to clarify, this was a decision in a case that we're not in, so
I
it didn't
understand.
get served on us. So it's not like we knew that we could, I don't think Jack even knew before right now.
Well, I can say this, Jacqueline Anciano, Director of Planning and Development, that was not the case that's pending for this county.
I understand.
I was made aware of it. It doesn't change, and sir, the chair closed the floor to he closed. So he'll have to, before you speak, he has to reopen it. But County Council, both our councils are correct. We didn't, it was not information we were bringing forward to this commission because it's not relevant in our case and on this application.
I'm sorry, I just want to clarify.
Okay.
It's not that we don't think it's relevant. It's that we found out about it way too late to share with anyone. I have not read a single word of it yet because I've been preparing for this meeting.
Understand, it would have been, for transparency, it would have been helpful.
And I agree
Some
on the-
people knew about it.
Yeah, I agree on the relevancy, thank you, but it's not our case that's pending. Maybe that is.
Yes. Let me, I think at this point, we've closed, you've very well stated your opinion on this. It's my understanding that the judge that gave the ruling today is also handling the county's cases, and I don't think the state's position has changed between Los Gatos and this county, and so I think it is very relevant, but that's not what's before us right now. What's before us right now is something, a very small subset of what we're trying to do, so I'll stay focused on that. Commissioner Levy.
Great, thank you, Mr. Chair. Based on what I just heard from staff, We have two issues we're looking at, not one, because one of them was resolved after the deadline. So if our very limited focus here, and it is very limited, is did they conform to the requirements in advance of the deadline, then we have actually two items and not one to look at. Right? Is that the case?
You asking staff or?
That's staff. I guess that's council probably, or staff.
Maybe repeat the question for them.
Oh, the question is, in a previous discussion, you're saying they submitted a revised map, and that revised map resolved the issue with the creek on the southern portion of the property. But that map was submitted after the close of the deadline. So do we take that map, the revised map, into consideration, or are we making a determination as to when the deadline happened, were they in compliance?
Elizabeth Vissers, Lead Deputy County Counsel. You're not making a determination about when the deadline was, when they submitted what in comparison to the deadline. They submitted a submission, and I don't have the dates in front of me because I haven't worked on this project, but in the staff report, it lists we're considering the department's determination on the submission of X date. Department determined there were 2 items that were still incomplete. That is the determination that is on appeal before the Planning Commission. So you're reviewing, was the planning department's determination that the resubmission was still incomplete because 2 items, according to the department, were missing? You're deciding, was that correct? Was it in fact incomplete, or was it complete?
Yeah, I think that answers my question, and that is that we don't really take that resubmission after the appeal letter into consideration, because that's not, we have to consider both the issues, not just one of the issues. And okay, great. That's one thing that was brought up by counsel here, and also by Alice Kaufman, is that you've had a number of builder's remedy projects approved. Your comment was they were approved prior to the approval of the housing element. Have we had builder's remedy projects approved after the approval of the housing element?
Deputy County Counsel Nicole Collins, to clarify, I don't think anyone said a builder's remedy project was approved.
No, okay, sorry. It moved forward.
Some
It was deemed complete.
projects
Thank you.
have been deemed complete. I believe we are now up to 16. Some of those were, I think only a couple were deemed complete before the certification of the housing element. And then there have been subsequent submittals that were deemed complete after the certification of the housing element.
Okay, so other applicants have been able to get through the process successfully. Okay, great, thank you. And one more question for council, and that is, the concept of, I guess, if it's a term, fair review, or be able to look at this, different people can look at it from different perspectives. I'm trying to remember the exact term that was used. But that people of, the people with different opinions consider this complete and incomplete. Council, maybe you can help me with the specific terminology. But if is that a standard in the state law?
If I may, the comment was reasonable people.
That's the reasonable. Thank you very much. That's the term.
That was the statement that was made.
Thank you,
and
thank you.
I would
Should've wrote
ask
that down.
staff, well, county council can respond, but I would ask staff to pull up the plan that doesn't have the flow on it. If you didn't see the arrows, you're reasonable. Would you have understood that plan?
That's exactly the reason I asked the question about the 2 issues versus the 1 issue, because on the 1 issue, on the geologic hazards, I was saying, well, I could see their argument there. On the flow issue, I think that was pretty clear. And that's the primary reason I asked that question, is because I don't think I can reasonably say that flow was being shown on that tributary. The seismic one, I think that there's still debate, and I'm still on the fence on that one. But that was the primary purpose of asking whether we were looking at 1 item or 2 items.
So through the chair, staff is sharing the plan set that is associated to the November 21st incomplete letter. So here on this sheet, you are not seeing the arrows for this for the flow or the call out. So as you can see here.
Sorry. Let me just make a comment, and then we'll go to Vice Chair O'Donoghue. My opinion on this goes to consistency over completeness. I think there was enough information to know that there is liquefaction in the area, and if you want to start to pick out who's got the biggest one, the smallest area, that to me goes to consistency. On the water, I could get to that same thing. It's going to be flowing downhill. If you want an arrow to show that, then that's fine. But that to me is a consistency argument. I share the state's view that I think it should be an iterative 90-day cycle. That's not what we're talking about here, but I'll just throw it out there. I was encouraged by the ruling. So, Vice Chair O'Donoghue.
Yeah, I'll just kind of echo off of that. I was thinking the same thing. You can see there's a 35-foot stream setback line, and why would they put that there if there was no water course there? You can see there's contours with a V channel. There's a call out for a proposed storm drain easement. Was this verbiage there from the beginning, or was this added in response to the comments? I think that's a question for staff.
I believe this was added in a response for one of the comments in the previous letter.
Okay, so before that, maybe there was no, I didn't look at the incomplete letter number 1, but if this was added in response to the incomplete letter, although it may not be what you're looking for, and certainly arrows makes it easier. They have arrows in the Alamitos Creek, so that that's really nice for somebody who's reviewing plans, but they did something here, and it may be inconsistent with the department's looking for, but it's not like they just ignored it altogether. So yeah, that's kind of how I'm leaning.
Commissioner Belska.
Pretty much the same thing, right? I mean, as a reasonable person, I look at this map and it's like, okay, there's a stream there. It's obviously flowing from the left to the right. This is nitpicking, right? It's, yes, maybe there should have been an arrow. An arrow would have been nice. I think, a quick phone call or email saying, hey, can you add an arrow, rather than deeming an application incomplete over the lack of an arrow, I find that a little excessive. And then for the geologic hazard zone, yes, it says not limited to, but I mean, if there's something specific county was looking for, ask for it, say, state, and make sure you include the county, right? I think it was a reasonable interpretation for them to go, okay, we included this thing you specifically list out here, it's there. Again, I think as a reasonable person, that information was present. Yeah, that's it.
Commissioner Hederly.
Yeah, I have the exact opposite reaction. I feel like the failure to even call out the creek, the tributary at all, is a far more glaring failure than the arrow the directional arrows. I am somewhat persuaded by the contour lines indicating that the water's going to go a certain direction, but the requirement was very clear to identify all water, whether flowing or not flowing. It's not identified here on this page in any way that I see. And with the seismic hazard zones, that I think is even more concerning, because it was clear in my reading of the checklist that that was intended to have you indicate where the fault lines are, where the landslide risks are, where the liquefaction is. And as you mentioned earlier about I guess I shouldn't direct it to you, since it was, as was mentioned earlier about the importance of objective standards and not subjective ones. I do feel as though the fact that all those other categories of seismic risk were called out in your geological study, it was a subjective choice by the applicant to not show any of them, despite an explicit call in both letters, in completeness letters, asking for exactly what it was that they wanted. So I do not believe that the application was complete as of November 21st. I think this is a much closer call than any of the other appeals we've seen, so I think it's a harder call to make. But if we're going to be consistent about whether complete means you provided what was asked by the deadline, that by November 21st, I don't believe that was achieved here. So I would make a motion to deny the appeal.
Do we have a second?
I'll second it.
We have a motion by Commissioner Hederle and a second by Commissioner Levy. Do we have any other discussion?
Yeah, I'll speak to my second. And that is, I've sort of split the difference here. I think that a reasonable person could say that they provided the geological hazard information, that the item there, 7P, did sort of state, it identified the two state items, the liquefaction and the hazards. And so I thought that was covered. But on the riparian corridor, I think it was not clearly defined at all. I don't think the riparian corridor was outlined on that plan. I don't think the flow was outlined on the plan. And so, I think that if we were taking a look at both, I think one of them, a reasonable person could agree. On the other one, I think it was fairly clear that it did not satisfy the requirements.
Okay, let's take a vote.
Commissioner Hederle?
Yes.
Commissioner Cohen?
Yes.
Commissioner Belska?
No.
Commissioner Levy?
Yes.
Vice Chairperson O'Donohue?
No.
And Chairperson Rouser?
No.
The motion does not carry. 3-3.
I have a question.
Go ahead.
If we're at 3-3, what happens to this application?
So there is a requirement in state law that action be taken on the appeal within 60 days. And if that is not done, then the application is deemed complete. So the effective answer is that if there's no motion that passes with 4 votes, then not the appeal, but will be deemed complete. The application will be deemed complete. So effectively, the tie break will go to deeming the project complete. And there's no requirement that you stay here forever and try to get to a motion that can carry forward, especially because it sounds like there's 3 on one side and 3 on another side.
There are obviously 3 unreasonable people on this commission, and I'm not going to say which 3.
Depends on your perspective.
Item 6, Stevens Creek Quarry Annual Report for 2024.
Sorry, I just want to confirm that everyone was was done with item 5, which, like I said, is okay, but before we move on, I just wanted to confirm.
We have families to get to.
Yeah,
so.
okay.
I have a
And
question.
thank you all the public who participated. We really do appreciate and value your feedback and input. Thank you.
There's a question.
I have a question for council. We don't have any wiggle room here, right? There's no way to split the baby on a decision like this. It's either yes, approved, no, denied. Is that correct? There's no halfway.
Yeah, I think you have to either agree that the project was complete or agree that it was incomplete, and it sounds like.
You're welcome to come to our side if you like.
No, but I would like to say something about it to the commission, if that's okay.
Absolutely.
If I
We
could.
love your input.
I do think that we need to be very careful and consistent and mindful of when we're substituting our personal preferences or judgment for things that are explicitly clear on the page or for staff's judgment. I would not like, as I said, I think this was a tricky one, but in general, I would not like to see us arguing about every single line on this version of the submittal versus this version of the submittal and this version, and deciding, well, you know, I think the county lines are important. Nah, I don't think the county lines are important. I think we do need to keep in mind staff's professional opinion there as well, and I hope that we all will do that. That's all.
Thank you.
Thank you.
Item 6, Stevens Creek Quarry Annual Report. Are we good to go with the staff report or this report?
We are indeed. Thank you, Commissioners.
Okay.
My name is Principal Planner Rob Salisbury. The item before you is an annual report for calendar year 2024 relating to compliance with conditions of approval for Stevens Creek Quarry. The owner is Stevens Creek Quarry Incorporated. The applicant is Jason Voss. Property address location is 12100 Stevens Canyon Road in Cupertino. The property consists of assessors parcels 351-10-019, 351-10-20, and 351-18-048. The general plan designation is Hillside. The zoning districts are HS-D1-SR, which is Hillside with a design review, and a Scenic Road combining district, and then Hillside with a design review combining district. Supervisorial district is 5. File number is PLN 07-1253-2024 annual report. And with me is Associate Planner Michael Schway, who's going to provide the presentation to you all this evening.
All right, good evening, Commissioners. My name is Michael Schway, Associate Planner and SMARA staff. The item before you is.
Did you just say smartest staff? I think you did. No.
SMARA? Yeah. SMARA. Yeah. Yeah.
I'm just giving you a hard time. You are the smart. You're smart too.
Right. The item before you is the annual report for Stevens Creek Quarry covering compliance with conditions of approval for the period of January 1st, 2024 to December 31st, 2024. This annual status report updates the Planning Commission for the reporting period of January 1st, 2024 through December 31st, 2024, pursuant to the following conditions of approval. Stevens Creek Quarry is a hard rock quarry located west of the city of Cupertino. The quarry operates under a use permit granted by the Planning Commission in 1950. In 1984, the use permit was amended and a reclamation plan approved that specified how the site was to be reclaimed once mining had ceased. The use permit was modified and renewed for a period of 20 years by the Planning Commission in 1996. This use permit has expired and the quarry continues to operate legally under the terms of a compliance agreement. There are two primary sets of conditions that regulate the quarry operation: use permit conditions of approval that cover Parcel A and mediated agreement conditions of approval that cover Parcel B. There is significant overlap between these conditions. Use permit condition number 53 requires an annual report be presented to the Planning Commission, and mediated agreement condition number 27 specifies that compliance monitoring for the mediated agreement shall utilize the same mechanisms as used for Parcel A. In order to verify compliance, the county SMARA team inspects Stevens Creek Quarry on a monthly basis. During these inspections, we make sure that all relevant conditions of approval are being complied with, that mining is occurring as specified by the approved reclamation, and that erosion control and water quality systems are being appropriately maintained. During this reporting period, the quarry was inspected every month, except for November, which did not occur due to scheduling issues. In addition to the monthly inspections, the county SMARA team verifies compliance by contacting other regulatory agencies such as Bay Area Air Quality Management District, Regional Water Quality Control Board, County Sheriff, and California Highway Patrol. As is noted in the staff report, aside from the SF Bay Regional Water Quality Control Board, each of these agencies has stated that they received no complaints and issued no violations during the reporting period. Later on in this presentation, I will discuss the issue reported by the SF Bay Regional Water Quality Control Board. As reported in years past, the county issued a NOV to Stevens Creek Quarry in 2021 for multiple violations of DH, fire, and building codes. The county and Stevens Creek Quarry subsequently entered into a compliance agreement which lays out a timeline to resolve these violations. Certain minor violations have already been resolved by the operator. The more significant issues still need to be addressed. The operator has complied with the timeline specified by the compliance agreement by making the required submittals on the dates specified in said compliance agreement. The reclamation plan amendment needed to correct compliance issues related to slope stability and ground cracks outside of the reclamation boundary is still in process, and there are details in the staff report. If any members of the commission have questions about this, we're happy to answer them. For the moment, I will focus on the recent letter of corrective action from the SF Bay Regional Water Quality Control Board and provide updated information on Stevens Creek Quarry's progress to address items in the 2021 NOV. The one new minor issue that arose during the reporting period is the 2024 letter of corrective action issued by the SF Bay Regional Water Quality Control Board. The issues and inquiries that the letter discuss include the unauthorized discharge of untreated process water from a sediment trap, untreated process water discharge which affected water quality in Swiss Creek, the purpose of the hose which connects the bag basin and in-stream pond 4. The two inquiries and requests, one was a request for an updated process flow diagram reflecting current conditions at the site, and an inquiry into the maintenance of sediment traps at the site. Stevens Creek Quarry provided a response to the SF Bay Regional Water Quality Control Board and is currently working with the water board to resolve these issues to their satisfaction. Moving on now to the financial assurance cost estimate review. Stevens Creek Quarry submitted the 2024 FACE on September 18th, 2024, and the FACE was approved by the department after the Division of Mining Reclamation's review. The 2024 FACE estimated that it would cost $10,596,873 to reclaim the quarry to standards specified by the approved reclamation plan. Stevens Creek Quarry increased the reclamation bond to that same amount to match the approved face. Staff's recommendation is to accept the annual status report regarding Stevens Creek Quarry for the reporting period from January 1st, 2024 through December 31st, 2024. This concludes my presentation, and we're available to answer questions. Thank you.
All right, thank you for the summary of that report. Just one quick question. That report's through December. Is there a scheduled time when that is supposed to be completed to you guys? It just seems kind of late, but I know we had at least 1 month that was on, that we delayed it, but ultimately, is that usually come out at December?
The time for this report has varied to some degree over the years. There is no mandated date on which this report needs to be brought to the commission.
Okay.
But certainly if it's the desire of the commission, we can try to get the 2025 report to you earlier than the 2024 report.
It just gets confusing if there's a lot of activity that's happening currently, and pretty soon you're giving us a 25 update of things that happened, and we're still now reviewing the 24. But in these cases, it's sort of steady at this point. And then the other thing was for the new members, the 2021 building violations. There was a lot of. At one point, we kind of got sort of upset, but ultimately there was a lot of confusion whether or not they had permission for those buildings or not. And so I just want to say it wasn't a complete in-your-face violation. It was more convoluted than that. So, but it seems like they've been very willing to address those issues once they were brought to their attention. Is that correct?
Yeah, I would agree. The operator is definitely working with us to come into compliance with these issues. They have complied with a lot of the requirements under the notice of violation, demolished a lot of the buildings that we determined were built without permit or modified without permit. So yes, I believe the operator is working diligently to come fully into compliance.
Right. Commissioner Belska and then Commissioner Levy.
Actually, along the same lines, I had questions about the 2021 notice of violations, because in that notice, there was a statement that the violations were to be remedied by September 14, 2021. I think we're a little bit past that date. And the staff report was saying that several of the buildings have been demolished. But so what is going on with the rest of the violations? Because, there were quite a lot, and September 2021 has come and gone, and can you give us an update on when we can expect all of them to be addressed?
As you said, there's quite a few, and so it's difficult to identify any specific date. Certainly, some of the larger issues that remain outstanding require review and approval of their reclamation plan amendment, and also which requires environmental review. And so that part of the process has caused some of the delay. But it's also important to recognize that the notice of violation deadlines aren't really applicable anymore because they did enter into a compliance agreement with us. So it's that compliance agreement that is now dictating the timeframes for when these issues need to get resolved. And we certainly, at the moment, as I said, we do have a compliance agreement. We do need to update it just to reflect the additional length of time it's taken to process the reclamation plan amendment and work through the CEQA process, which is required for that amendment.
Okay, thank you. Two more quick questions. Item 21E from the table that you provided says that the noise tests weren't conducted. Can you explain why the requirement is county will conduct a minimum of 2 random noise tests annually and report the results? No noise testing was conducted by the county.
Yeah, that requirement was put into place many, many years ago. And in the file research that I did when there was a request to audit the department's compliance with this and the quarry's compliance with various conditions of approval. Those noise studies were done for many years when this use permit and the mediated agreement were first put into place. No violations of the noise ordinance were ever reported during that period. And there's an agreement between the operator and the department at the time that for that reason, the ongoing noise study did not need to continue. I will say also that the noise ordinance is, and noise testing is usually handled by the Department of Environmental Health. And there have not been any noise complaints received by Environmental Health during this reporting period. Certainly, if the commission prefers, we can continue to do that noise testing as required. But again, many years ago, it was decided that due to the lack of exceedances and the lack of complaints, it was simply not necessary to continue to do those tests every single year.
So is there active blasting, like explosions happening at this quarry, or no?
No, they don't blast at that quarry.
Okay, thank you.
Commissioner Levy, and then is it Heatherly? Commissioner Heatherly, you're?
I think.
Okay.
Great. Thank you. It's really glad to hear that the quarry is doing their best to comply. How are they doing against the compliance agreement? I look at the dates in the compliance agreement. Most of them are well past. Are they making the dates? Does the compliance agreement need to be worked on additionally?
I would say that those dates are not fully within the operator's control. The EIR process has taken longer than anticipated, and it's a bit of a technical reason. Essentially, the issue is that certain of Stevens Creek Quarry's parcels are within the jurisdiction of the City of Cupertino. City of Cupertino does not have a Surface Mining and Reclamation Act ordinance. And they also don't, as I understand it, don't allow mining as a land use. And therefore, it's not possible for this department to issue or approve a reclamation plan or a use permit covering those portions of parcels that are within Cupertino. So we have been, we directed the operator to engage with Cupertino to go through the process of detachment, which county staff has also been participating in, whereby those Cupertino parcels would be returned to county jurisdiction, at which time we would be free to approve a rec plan covering those parcels and a use permit covering those parcels. I believe the last time that happened was in the 70s, and so the process is having to be rediscovered, if you will, so it has taken some additional time, but we are still working through those issues, and the operator is fully working with us to do so.
So the operator is on board with the annexation, sort of the reverse annexation, right, for the annexation back to the county. Is this something that you're working with LAFCO on currently?
To my knowledge, we have not engaged LAFCO yet, but I could certainly find out if the operator in Cupertino have had discussions with LAFCO and report back.
Yeah, because this is purely a LAFCO issue, right? You know, jurisdictional lines.
Yeah, but Cupertino would be the one engaging LAFCO to accept it.
It would be both, right? You have both, two parties would have to agree to this. But, well, actually, LAFCO has to, we make a presentation, LAFCO makes the decision on where jurisdictional lines are. So.
I understand, but Cupertino would initiate the application to annex that portion.
It could go both ways. That's not here or
Yeah.
there.
I was going to say, we didn't direct Stevens Creek Quarry on what to do to solve their problem. They decided they wanted to pursue detachment, and based on our research, that's a process you're right, applied through the City of Cupertino. LAFCO may be involved at some point, but it's not a process that is going directly through us, and they would need to complete the detachment or get approval of the detachment before it could come to the commission to consider consider whether to approve a use permit and the proposed reclamation plan
Oh,
amendment.
okay, great. Whatever happened to the road that went between Stevens Creek Quarry and Lehigh? That was something, I mean, that was an in-your-face violation, if there ever was one. And I don't see that referenced here, or if I'm missing it.
So when the county became aware of that, the use of that haul road to transport material, we issued a notice of violation. That notice of violation, though, was on Lehigh property,
It was on Lehigh.
not Stevens Creek Quarry property, which is why it's not mentioned in this particular
Okay, yeah,
staff
but-
report. But the annual report that's coming up next will
And say, hold on to that question.
Yes, yes.
We'll
But it
speak
was
to
a
that
road
issue.
between the two of them, I mean, so it takes two to tango. Okay. Finally, a question on how long is the lifespan of this quarry? I mean, how long are they still going to be mining? Do we know?
Yeah, it's a great question, also difficult one to answer with precision. The rates at which they extract can vary over time. I think under their current rec plan, they're getting relatively close. I would think within 5 to 10 years of being out of material that they can extract and produce aggregate from. I think the proposed rec plan amendment would buy them some additional time, probably in the order of another 5 to 10 years.
Okay, great. And just, I want to thank Stevens Creek Quarry for not having trucks on their road when I rode my bike by a week or so ago. Often it's a very scary road to ride when those big trucks are on there. So I was really happy when I rode last Thursday afternoon and there were no big trucks on that road. So
That was Bob Levy's condition of approval.
that's exactly right. Get those trucks.
Commissioner
off when I'm
Hederle.
riding.
Yeah, I just wanted to follow up on the issue of the conditional use permit. Am I correct to understand that you've got the draft EIR has been prepared, it's ready to, the county could move forward with considering a CUP at any point now, but we're waiting to see how this detachment issue is resolved? Is that correct?
I think it's more accurate to say the EIR could be released really at any time, pending some revisions to acknowledge the detachment process. EIRs, of course, have a mandatory comment period, and then a final EIR needs to be prepared that responds to all substantive comments received during the comment period that relate to the CEQA analysis in the EIR. So once that process is done, then the item could be brought before the Planning Commission for approval.
So
If I could just add, so the draft EIR is not being held once it's ready to be released. The EIR process was a bit delayed because the proposed detachment is now a part of their proposed project. And at first, it took them a while to figure out that that is the route that they were going and the processes. And then once they confirmed, yes, we are pursuing detachment, then we reached a point of needing to integrate that into the draft EIR. And I think that it is continuing to make its way through the revisions process and will be released as soon as it is ready. The part that cannot happen until the detachment is potentially approved is the Planning Commission deciding whether to grant a use permit over those parcels, because they can't grant a use permit over parcels that are still part of Cupertino, as Rob explained.
Thank you. That's helpful. And an additional question is, if they're currently operating under a compliance agreement and this mediated agreement, and maybe this is a premature question, what happens when we start thinking about a conditional use permit? Is there any urgency, any authorities or enforcement powers or obligations that fall upon the county under the current arrangement that would be different with a CUP? Like, are we unable to exercise any authorities now because we don't have a CUP?
Under the terms of the compliance agreement and the mediated agreement, I believe those two in conjunction give the county largely the same oversight authority as we would have and will have, provided a conditional use permit is granted by this body. So I believe we're able to enforce and regulate sufficiently now as we will be able to should another conditional use permit be granted. And I would also, again, like to say that, you know, the operator is fully cooperating and abiding by the conditions of approval in the use permit, even though it is technically expired.
Thank you very much.
Okay, so I will open the public hearing.
For public comment, we do have one hand raised on Zoom.
Victory. We have someone paying attention. Thank you.
Okay, 2 minutes. Rhoda Fry, you will have 2 minutes.
Rhoda.
Hi, good evening, Commissioner. Long time no see. It's nice to see some new faces. You know, I've been following these things since before these stipulated, what is he called? These compliance agreements existed. And, you know, basically you're out of compliance and then you say, oh, okay, well, we'll give you some more time. So that's what a compliance agreement is. It's a relatively new thing, but it's been going on for a really long time. And I think we just need to get these guys into compliance. The other thing that I found really shocking was when that huge notice of violation came around. There were a lot of public safety issues in there. Fire, and then of course there was unpermitted structures. And it was just really surprising to me that these issues have been so long-standing, and it just made me wonder about the general oversight of the property. As to, I'm a Cupertino resident, and you know, I think of that slice of property within Cupertino as being somewhat of a buffer area. And quarries generally have buffer areas. For example, over at Lehigh or Permanente Quarry, you've got about 600 acres that's being used and 33,000 acres that, you know, are not active. So I would, on the face of it, I would be opposed to that happening. And then, yeah, I agree that, thank you for noticing these reports are really late. Very worried about more water issues. This is not new. We've had water issues before. Keep in mind, Swiss Creek goes right into Stevens Creek Reservoir. They're right across the street from the reservoir, and it's not okay. The other thing, they do have an agreement to not.
And that concludes public comment.
All right. Ms. Fry, it's always good to hear from you. We'll close the public hearing. Any other comments from commissioners? If not, I will accept the report. We don't need to vote on that, do we? We do?
We do.
Okay. Well, you know what my vote's going to be, so let's take roll call.
Well, I need a motion and second first.
So moved.
We have a motion by Commissioner Levy and a second by Commissioner Cohen to accept the report.
Thank you. Commissioner Hederle?
Yes.
Commissioner Cohen?
Yes.
Commissioner Belska?
Yes.
Commissioner Levy?
Aye.
Vice Chairperson O'Donoghue?
Yes.
And Chairperson Rouser?
I approve.
The motion carries.
Item number
Thank you.
7.
Thank you, Commissioners. My name is still Robert Salisbury, Principal Planner for the County of Santa Clara. And this is, the item before you now is the annual status report, the 13th such status report for Lehigh Quarry, covering the period of July 1st, 2024 through June 30th, 2025, relating to compliance with the 2012 Reclamation Plan Amendment Conditions of Approval Mitigation Monitoring and Reporting Program, annual surface mining and reclamation act inspections, and financial assurance cost estimates for the Permanente quarry. The owner applicant is Lehigh Southwest Cement Company. Property address location is 24001 Stevens Creek Boulevard, Cupertino. Assessor's parcel number is 3510913 020 022 023 025, and assessor's parcel numbers 351-10-005 and 033 and 037 and 038, as well as assessor's parcel numbers 351-11-001 and 005, 006, 007, and 081. The general plan designation is hillsides, with some areas designated as other public open lands, and then some parcels have an urban service area designation, Cupertino, for their general plan. The zoning is HS-D1, as well as A-D1, A1-D1, and A1-20S-D1. Supervisorial district is 5, and the file number is PLN 12-2250-2023 annual report. So with me is Associate Planner Reva Kakaria to provide the staff presentation on this item.
Good evening, Planning Commission. My name is Reva Kakaria, and I'm an Associate Planner and another SMARA team member.
Another smart team member. I love it.
The item before you is the 13th annual report on Lehigh Permanente Quarry, covering the time period of July 1st, 2024 through June 30th, 2025. I'll provide a brief overview of the annual report and then take any questions that the Commission may have. So to start with a little background, Lehigh Permanente Quarry is a limestone and aggregate quarry located in unincorporated Santa Clara County within the eastern foothills of the Santa Cruz Mountain Range and west of the city of Cupertino. Lehigh Permanente Quarry operates under a vested right as determined by the Board of Supervisors in 2011. This means that Lehigh does not need a use permit to conduct mining activities within a specified geographic area. Lehigh does have an approved reclamation plan that was approved by the Board of Supervisors in 2012, and the conditions of approval associated with the reclamation plan require Lehigh to submit an annual report on compliance with the conditions of approval and require that an annual report be brought to the Planning Commission. During each annual report, we report on a variety of topics, including reclamation activities, compliance with conditions of approval, primarily water quality, and financial assurance cost estimate review. We also report on any violations that may have been issued during the reporting period and the status of any applications that are in progress. As noted in the annual report submitted by Lehigh, there was minimal reclamation during the reporting period. Lehigh did conduct maintenance of erosion and sediment control systems, which included removing 295 cubic yards of silt from silting basins in various locations, including the west and east material storage areas, the Jaeger Yard, Pond 20, and rock plant areas. Additionally, upon issuance of a grading permit on June 12, 2025, Lehigh began grading work for the Permanente Creek Restoration Project and is in progress of obtaining grading approval for the PCRP Pond 22 project. Regarding water quality, Lehigh provided water sampling and testing data for the reporting period. Water is discharged into Permanente Creek at 2 permitted discharge points, and the selenium concentration in the discharge water ranged from 0.19 to 4.6 micrograms per liter, which is below the water quality objective of 5 micrograms per liter pursuant to the San Francisco Bay Regional Water Board. Based on this data and Lehigh's continued implementation of water treatment and stormwater monitoring, Lehigh is in compliance with the conditions of approval related to water quality. Staff contacted several agencies, including the United States Fish and Wildlife Service, the United States Environmental Protection Agency, the California Department of Fish and Wildlife, the San Francisco Bay Regional Water Quality Control Board, the Bay Area Air Quality Management District, the City of Cupertino, and the County Department of Environmental Health. None of these agencies issued any violations during the reporting period. Regarding Lehigh applications, the 2023 Reclamation Plan Amendment was deemed complete on January 27th, 2025. The county is currently preparing a subsequent environmental impact report to the 2012 Reclamation Plan Amendment EIR. The Permanente Creek Restoration Project grading approval received a grading permit on June 12th, 2025, as previously mentioned, and Lehigh commenced work on the project in August of 2025. The department's land development engineering staff have been regularly inspecting the work as it progresses. And lastly, the application to restore the Pond 22 area of Permanente Creek was deemed complete in September of 2024. Staff is in the process of completing an addendum to previous environmental documents. The 2024 financial assurance cost estimate was approved by the department on August 24th, 2025, for an amount of $79,859,963. The county holds a bond in the same amount. In conclusion, staff recommends that the Commission accept the Lehigh Annual Status Report number 13 for the period from July 1st, 2024 to June 30th, 2025. Thank you, and we're happy to take any questions.
Commissioner Levy, do you have a question on a particular road?
No, I don't, but as long as you're asking, I might as well ask a couple questions. I saw in here the various phases, phase 1, phase 2, phase 3, and on one of the documents, I don't remember which, but it said phase 1 is ending this year, and another one says, or phase 2 is ending this year, another one said phase 1's ending this year, and I was very confused because there wasn't consistency on the timeline between the phases within the documents.
My apologies for that confusion. We'll have to look into that, make sure it's clear next time. The bottom line is that any phasing in a reclamation plan is speculative, and it's created at the time that a reclamation plan is first prepared and then approved. And because Lehigh is a vested quarry, they don't have a use permit that limits the lifespan of that operation. So the speed at which a quarry mines and reclaims lands, certainly when it's a vested quarry, is really based on market conditions and their progress and other factors that are really not under the county's direct oversight. Again, because they're a vested quarry, they do not need a use permit, and there are no time limits associated with a use permit, like there would be with a use permit.
But is there time limits on components of the reclamation plan that they have to adhere to?
No. Really, there are limits based on production. So should production fall below a certain limit, then the quarry would be designated to be in an idle status. They can be idle for up to 15 years. And if they never increase production back up to the level that means they're not considered idle under the law, then at that time they would be required to start and finish reclamation. The law was written that way in order to allow for market fluctuations and not have operators go out of business when market conditions are temporarily low.
So there are currently no mining activities taking place, so any type of activity they're doing is based on stockpiles. And so how long would it be until they're considered idle based on the use of their stockpiles?
So the production limits are based on export tonnage. It's not based on tonnage extracted from.
There's no more extraction, so.
Yeah, no more extraction is occurring, but they are still technically active because they are still producing and selling aggregate from the existing stockpiles.
Exactly. That's what I was asking, is how long will that stockpile last before we're in a position where it's idle and they have that 15-year clock starting to tick?
I do not know the exact volume of stockpiled material that they have, so I cannot answer that question, but I could certainly look into it and get back to you.
That'd be great.
Okay.
A year from now, if we do that.
And I would also say that they have a reclamation plan amendment in process, which is clearly a plan to fully reclaim and shut down the quarry. And so I think, if I could speculate a little bit here, I think Lehigh is obviously hoping that reclamation plan gets approved, it is significantly different than the 2012 reclamation plan. And then once that reclamation plan, should it be approved, I think full reclamation would likely commence shortly thereafter.
Yeah, well, on that new plan, they're talking about the West Materials Service Area, if that's right, leaving all that material in place and not using it for the reclamation plan and trucking in materials instead. Is that something staff supports, or do we want to, seeing all those trucks, or do we really want to see the material that was taken, that was stockpiled, put back where it belongs?
I wouldn't want to make any kind of statement. It's, the item is not before the commission at this time, and we're still doing environmental review.
Yeah, okay. Yeah, but that sounds like one of the concerns that I'll be looking at least. The other one is part of the reclamation plan, do they talk about land use at all? For example, how is the property going to be used once the reclamation takes place? Are we going to see, some being open space, recreational, housing, et cetera? Is the land use components of it included in the reclamation plan?
Yes, it is. Each reclamation plan has to specify the end state of the quarry once reclamation has been completed. And as is common with a lot of quarries, the end use that's specified in the plan, which also to some degree dictates the reclamation standard that's applied, is open space.
Yeah, and so primarily be open space, but there may be components that aren't. Is there a committee or anything that gets put together to work with Lehigh in determining what that reclamation plan looks like as far as land use components?
We have not been engaging with Lehigh as to that final designation. It's really, there are some limitations on what can be specified in a reclamation plan. For example, the reclamation plan can't specify that it's going to be high-density housing when there's no entitlement for that end use already in place. And the time frame of even the 2023 reclamation plan, which is still in process, is about a 40-year time horizon. And so I think, again, if I could speculate, I think Lehigh is just realizing that reclamation is going to take a significant amount of time and are not in any serious hurry to try to determine what the use of the property will be once reclamation is complete.
Okay. That's right. It's probably going to be way past my tenure on the commission, but I'd be very interested in seeing what they do as far as the land use component is concerned. I mean, there could be a housing piece of it along the road where there are services. We'll have to see. All right. See, that's what you get for asking me.
So you're okay with the road, the use?
Well, that road doesn't go, Stevens Creek they ride on, and they're not really on Stevens Creek.
Well, they used it to get on their, it was on their property.
Yeah,
but,
not going up.
any other questions from commissioners before I open the public comment? Nope. Let's open the public comment.
We do have one, apologies, we now have 2 speakers on Zoom. We can do 2 minutes each. Our first speaker is Rhoda Fry. Rhoda, you will have 2 minutes.
Hi, good evening again. We have a hillside there that is protected by a deed, the 1972 Ridgeline Protection Easement, viewshed easement, too many words. But anyway, we're losing it. It's crumbling, it's crumbling, it's crumbled about 50 to 75 feet already, and we need to protect it. And we keep on delaying this reclamation, and we're gonna lose it. And you're gonna be able to see that hideous caldera from everywhere, including right now. You can already see the scar of the West Materials Storage Area from across the bay. You can see it from Turtle Valley. You can see it from a lot of places. So we got to get on with reclamation. I am glad to hear that we're moving forward on the lawsuit mandated repairs at Permanente Creek. As far as the reclamation is concerned, I want to kind of let you know this, is that there's this East Material Storage Area, and Lehigh did not want to move it because they back in 2012, which was an illegal mountain that they built, by the way. They didn't want to move it because it would take too much fuel, would create too much pollution. So now instead they're talking about trucking stuff in, you're telling me the trucking stuff in is actually less polluting than actually moving the east material storage in. Of course, the west material storage had been mentioned as well. Now, the other thing I want to say is that they have resurrected the rock plant, which if they had any vested rights to it, they lost it by stopping operating for 10 years. And but we're getting a lot of traffic in the middle of the night. And I think that they should, it's a public nuisance. I'm not personally affected, but it is public nuisance. And I think that, you know, they should be held to the same timeframes as Stevens Creek. The other thing is there was a 5 million gallon spill that was not reported to the SOES. And the county's not doing anything about it. They're the Coupa, and I'm not happy about it. Thanks.
Our next speaker is San R. San, you will have 2 minutes.
Good evening, Chair and Commissioner. Speaking on behalf of myself only, I spoke earlier as well today. So my street is directly behind the quarry, behind the Lehigh Quarry. And so all of my neighbors are backing up to the quarry. We'd like to request that the quarry be required to only allow trucks after 6:30. I believe Stevens Creek Quarry has a use permit that does enforce hours of trucking, and that starts at 6:30. And trucking is prohibited on the weekends. I believe the Lehigh Quarry is not enforcing any hours of operation, and so we have trucks that are coming in at 3 a.m., 4 a.m., 4:30 a.m., and so on. These trucks are squealing brakes, so it is quite a noise nuisance that is operating at the early hours of the morning. So appreciate if anything can be done to try and address this between the county and the quarry. The other thing I'd like to say is if we're talking about reclamation, maybe they should use the railroad and the rail tracks to do some of the reclamation, because the number of trucks that they'd have to run to do reclamation from outside in is going to further increase the truck traffic. And rather than seeing truck traffic, we might want to see or test the concept of running the railroad again. And finally, I'd like to see if the quarry can be completely annexed into the Rancho San Antonio County Park system, so that all of the quarry land becomes open space preserve and county park rather than any sort of housing. As we talked about, we cannot get insurance even further downhill from the quarry. We cannot get insurance. And soon there is no choice left. Even the state policy is unable to insure these areas. So it's turning into a place where you can't have a mortgage, because if you don't have insurance, you can't have a mortgage. So appreciate looking at treating this as open space preserve. Thank you.
That concludes public comment.
Is there any restrictions on trucking and hours and number of trucks or anything that they have to abide by?
By virtue of their vested status, there are no mandated times or hours of operation.
Right, okay. Is that, I'll close the public comment if I didn't know just now. Would anyone like to make a motion to accept this report?
I'll make a motion to accept the report.
Second.
Okay, we have a motion by Commissioner Belska and a second by Vice Chair O'Donoghue. Can we take a vote?
Commissioner Hedderly?
Yes.
Commissioner Cohen?
Yes.
Commissioner Belska?
Yes.
Commissioner Levy?
Yes.
Vice Chairperson O'Donoghue?
Yes.
And Chairperson Rouser.
I approve.
The motion carries.
I do not have a report other than I just say thank you for your flexibility in meeting an hour later today. I do appreciate that. Any other reports from commissioners? No. Do we have a report from County Council? No. Planning Commission Secretary is not here.
That would be me. No.
Okay, you're going to give that report?
But I do have one from the director. We're going to strike.
Deputy Director, there's none?
No.
So just go straight to 13.
I just wanted to let the commission know that the Sergeant Ranch Quarry development application was withdrawn. That property has been sold to the Peninsula Open Space Trust Post, and so that application is gone.
What are we going to do with not having any correspondence to read anymore. That's just, okay.
And I also want to let the commission know that we are in the process of securing an interim deputy director that will serve beginning in March. We're solidifying that contract this month and over February. And so at the time that they join us, we will bring them to introduce to you.
The position, or you have a person in mind already?
We have someone that we have secured.
Got it, okay. All right. Announcements and correspondence. Number 14, currently 2 vacancies, and the county provides reimbursement to appointed commissioners for blah, blah, blah. And if we had got any correspondence, we received it. And with that, I adjourn to the February 26, 2026 meeting, if it occurs,
And
here
if you
at these
would,
chambers.
we do have salad for the commission in the back, so if you weren't able to indulge before the planning commission commenced, please go back and enjoy. And there's some little snacks that you can take as well. Thank you all for being flexible.
And thank you for the members in the audience that stayed with us the whole time.
I'm trying to practice being quiet. I am. I did.